The history of criminal law is not clean, if it could be considered legal at all. Suspects of crimes were beaten, bribed, intimidated, and even threatened until they confessed, even if the penalty of the crime was death. Such as in the Star Chamber, where suspects of crimes were beaten and tortured relentlessly until they confessed to crimes that they probably didn't even commit, and were then executed for disobedience of the very strict law. Not 100 years ago did the rights against self-incrimination come around, the right to remain silent, and the right to an attorney. And even then, there were no rules that applied to an interrogation during an interrogation. That was until the Miranda v. Arizona court case of 1966 came around to scrap all of that and forever hold the first base requirements of an interrogation. The Fifth Amendment, also known as the right to remain silent, was created so during an interrogation, the suspect at any time could plead the Fifth, or take to the Fifth, which would then stop the interrogation. The Sixth Amendment, also known as the right to an attorney, allows a suspect to consult with a lawyer, also known as an attorney, at any time pre, during, or after an interrogation, and also allows a lawyer to be present during an interrogation. On March 2nd, 1963, an 18-year-old woman, whose real name was not stated, was heading home after work until she was kidnapped and raped, then was brought home. The woman then picked Ernesto Miranda from a lineup. During none of this time was he ever read his Fifth Amendment right to remain silent, or Sixth Amendment right to an attorney. He dropped out of the 9th grade in school, and ever since then has been suspected multiple times for auto theft. Ernesto Miranda has also raped multiple women and has also mugged a few girls too. He gave and wrote a confession of guilt, which was then used against him in court. He was convicted to 20 to 30 years in prison. His attorney believed that the confession was not to be used because he wasn't informed of his Fifth and Sixth Amendment rights during and after his interrogation. Before the Miranda v. Arizona court case, though, he was able to get married and has had a kid of his own. That did prove to be his downfall, though, and that is because when he was in jail, his wife asked him if he had committed the crime, and he admitted it to her. Which, after his conviction was reversed, did lead to him being tried again, and then proven guilty. The case was carried up 2 more courts to the Supreme Court, also known as Ultimate Court, that considers rights and has the authority to rebuke convictions, on the premises that he testified against himself because he was questioned prior to knowing that he could consult an attorney before answering questions. The case was then voted 5-4 in Miranda's favor, with more than 100 pages in opinion. Although he confessed, Ernesto Miranda won his case and was released because he was not aware of his rights. And thus came the Miranda Law, which made it a requirement to state the Fifth and Sixth Amendment rights before any interrogations, or any information gained is prohibited from court submissal/usage. After he was released on parole from his conviction, he decided that he can make a couple quick and easy bucks from autographing Miranda Law cards. He was caught in violation of his parole, though, for having guns in possession. Yet, luckily for whoever would have been his next victim, Miranda was killed in a bar fight from being stabbed to death. Well, at the time, Ernesto Miranda's pocket had 2 Miranda rights cards inside of it, which, ironically, one of them was used to read his killer's Miranda rights at the time of him being arrested. According to Kevin Vibert, a 56-year-old attorney specializing in criminal law,
Miranda law, it's all part of the civil rights movement back in the 60s. It's helped and shaped the way people think as far as civil rights are concerned. It's put an end, I think, a lot of end to abusive police investigations.
many did fear that the Miranda Law made an officer's job harder, and that it would set criminals free to roam the streets. Yet the information taken did show that the amount of confessions acquired hasn't decreased, if it hasn't risen, because suspects have started to waive their rights, choose not to use them, out of feelings of safety from having been told their rights. Yet the Miranda Law was made to ensure equality, and to help protect innocent people from being convicted upon being accused of a crime. One thing that helped factor into this decision is the Star Chamber. The Star Chamber was designed by the British government and was used to acquire confessions from suspects. In the Star Chamber, if you said no, they would call you a liar and would torture you. But if you did say yes, they would torture you and then sentence you to death. The Miranda Law has saved many innocents, but probably has set criminals free too. Then again, when is there ever anything without the lies and manipulations that man can play? And this applies with or without the Miranda Law. According to Alan Richards, a 30-year-old Seattle police officer,
the Miranda, when you read them, it advises the suspect of their Fifth Amendment and Sixth Amendment. And basically the Fifth Amendment is their protection against self-incrimination. And the Sixth Amendment is the right to counsel. A lot of times, most departments have some sort of recording. We're audio, video recorded almost all the time. Anything they say can be thrown out and not used in court because it wasn't post-Miranda. It was before they knew their rights. Since that case, that everyone had to be advised of the rights, and after they're arrested, though, after they're in handcuffs, and before any questioning can happen, Miranda rights have to be read.
the Miranda Law has been weakened over time and now remains with a small effect on interrogations, but it still does remain the first ground rule for an interrogation, and I sure hope it is not the last.